Everyone, good evening. My name is Tanuj. I know my orange shirt and my orange background, they are not really going well, but I wanted to show you Lawctopus t-shirt, announcing formally Lawctopus Law School as well. Thank you for joining in. Really honored that, we have got probably country's top two mooters, now they are coaching mooting teams as well. So we've got Saunak Rajguru, he's currently at JSA also. We've got Tushar, who's been an exceptional mooter. Thank you, Saunak. Thank you, Tushar, for being with us today. Uh, so we've got around 250 plus participants. Thank you everyone for joining in. Uh, Not easy on a Sunday evening, but thank you for your commitment to your learning and growth. I think we'll start. Tushar, I'll request you to take over. Tell people about the fundamentals of mooting. I think before that, guys, there are a couple of things which I would like you to take notice of. One is the Q&A box. So if you have joined in from your desktop or even from your mobile devices, you'll see the Q&A box. Please feel free to drop in your questions on the Q&A box. Also on the chat, sort of the box, you would see a brief structure on how this presentation or how this webinar will go. So please do go through it. We'll be covering a lot of stuff. It's going to be an intense, fast session. With that, Tushar, it's over to you.
Thank you for your wonderful introduction, Tanuj. It's a pleasure for me to share this panel with Saunak, who's been a great friend for me. And yeah, let's just start with the basics of mooting. Let me just give you a background as to what is mooting and how do we moot actually, why do we moot. So basically, what is a moot? A moot is basically a presentation of legal issues or a problem in a simulated court hearing. Just like it is the most nearest experience of what a law student can have. We all dream of arguing in courts, and I guess moot court is the most closest experience where a law student can have while we moot. As to people are really confused with the fact that they confuse moot courts with trial advocacies or maybe mock trials, as I would say. Those are entirely different. Why? Because what we understand is a moot court is basically based on the assumption that evidence has already been tested and focuses on the entire question of law. Whereas in trial advocacy, we have chain of events and we establish facts right in there. Mooting can be actually very beneficial for a person professionally as well as personally, because of the very fact that mooting, even though it's a nerve-wracking exercise, mooting can have tremendous benefits because of the very fact that it builds your confidence, it enhances your public speaking skills, it gives you the necessary skills to outshine in the legal market. For the very fact that often hirings also take place when you have certain moot court achievements, because it demonstrates that you have actually spent your time well during law school, you have been inclined towards legal research, you are well versed with public speaking, so it gives you an all-round personality as a whole. Right, I would leave to Saunak to add to it if there is anything.
Thank you, Tushar. I think that was a great introduction about what mooting is all about and how one should approach towards the same. So, hi everyone. Good evening to one and all. Thank you, first of all, to be present in such amazing numbers. It's 410, I guess, as of now. So basically, in this particular segment, what we have tried, me and Tushar, will basically be covering a series of aspects as to how one should approach towards the moot court propositions, as well as the entire, pave the way towards the whole preparation stage, followed by the memorial stage, followed by the oral advocacy aspects, and how one should make all endeavors to culminate that into a moot court win. I think that's why almost all of us do and try our best to moot, right? So basically, to start with, I think my first and foremost focus will be certain key aspects which I'm sure most of you ignore. Number one is how exactly one should ensure that a team is prepared in a proper manner and what should be the composition in a team. The first aspect, therefore, is understand your team well. Make sure that you have a great composition in your team. The ideal composition is of a 2-speaker and 1 researcher in a general moot. Sometimes that can be, 2 speakers or 3 speakers for that matter, and more than 2 researchers in some moots. Therefore, the primary, thing that you should keep in mind is the key attributes of a speaker. Therefore, whenever you choose a moot and whenever you have a team, make sure you have someone who can rationalize things well, who can analyze the things well. Therefore, the analytical skills and the rational aspects will be key attributes of any speaker. maybe someone who can logically support the submissions instead of being very technical. No judge will appreciate someone being technical and just cite case by case during the oral advocacy rounds. Therefore, what matters is one should be absolutely logical in the approach, because the law is based on logic. After the logic, I'm sure the law will ultimately follow the logic. Therefore, the most important aspect that you should look for in the team, or if you want to yourself be a speaker, make sure you understand the fact that you need to rationalize things well, you have to analyze things well, and ultimately put across the arguments in line with what the law requires you to do. Therefore, choose the team well. Do not go after friendships. Please make sure that you have a professional relationship in the team. By that, I do not undermine the fact that friends can be moot teammates. All I'm trying to say is merely because he or she is a friend does not mean you will make a great moot team. Therefore, what you should keep in mind is prepare a team in such a way that there'll be harmony within the team. All of you are compatible with, number one, within yourself, and number two, with the proposition also. Because it's very important to have a common goal. If you are doing, say, for example, Stetson International Environmental Law moot, or maybe a constitutional law moot, and there is someone in the team who is not interested in the subject area at all, then it's a detriment for the said person as well as the whole team, because one person not interested in the moot, then that means the whole morale of the team will go down, because it's an exhaustive process for sure. Maybe sometimes 2-3 months of preparation, sometimes 6-7-8 months of preparations that go into one single moot. Therefore, it's a tiring, exhaustive process. You need to ensure that you are constantly interested by way of motivating yourself, and that can happen only by way of having good teammates. Once the team is ready, I think the next important step is choosing the right moot. Now, it's very essential for you to understand that you should not go by the brand name of the colleges. You should not go merely by the fact that, okay, this or that college is a really great college, I should do a moot there and that will add value to my CV. No, it doesn't happen that way. Maybe some rural area can have a great college, or maybe the name of the college might not be that known, but maybe the proposition is really interesting. Maybe the area of law that they deal with, so far as the fact sheet is concerned, interest you and also furthers your career perspectives. In that situation, I think I don't see any kind of inhibition that should come your way in participating in that moot, right? Therefore, choosing a moot should be all about your comfort zone, should be all about the interest factor, and because ultimately you need to be motivated throughout the preparation of rounds. There is no point in doing a competition law moot if you're actually interested in intellectual property law. Similarly, there's no value of even doing that kind of a moot, because ultimately when a recruiter will ask you what did you do in furtherance to your interest towards competition law, you will say that no, I did an intellectual property law moot, and he'll say why, and you have no answer to that. Therefore, make sure you bring these two aspects in tandem and keep them in mind when you choose your next moot. The next thing that I should cover here is the pre-proposition stage before I leave the forum for Tushar to go into the proposition stage. Now, please understand, in the pre-proposition stage, once your team is ready, once the moot has been finalized, and once you have some fair bit of idea as to what will be the area of law that will be governed in that moot. For example, if you're participating in JESUPs, it ideally denotes a particular area of law that the proposition will be dealing with. And that happens much before the proposition is released. Similarly, for example, if you're going for Stetson, it's a known fact that they conduct a moot in international environmental law. I'm sure your moot court organizations and associations will help you guide as to what were the past propositions, or you can also conduct that exercise and due diligence yourself, where you can actually go for the analysis of last 4 or 5 years proposition of that very same college, because ideally they keep harmony between both, or rather more than 2 events, and they concur with the previous law, because if they have done in constitutional law, they'll try and keep doing in constitutional law. For example, let's take an example of Tushar's college, UPS. They ideally do the Paras Dewan moot, right, which comes in energy laws. And they focus on energy laws, and that's the specific kind of a moot. Therefore, you're doing the Paras Dewan energy law moot, you should start reading the very basics about the whole area of law and the matter of subject. Because please understand that I think what is supreme for any interpretation of the law is understanding the statutory intention behind the same. Therefore, if you are analyzing a particular provision of a law, if you have to make any submission whatsoever regarding that act or the statute or even the constitution, understanding the backdrop, understanding the history, understanding the travaux preparatory, as we may call it, in terms of the bill stage, what happens in the parliament, how the discussions are going on, what is the intention behind having a particular word in a particular section or a particular provision, why there is a proviso, why was there were a requirement even of having it as a proviso and not as a main substantive element in the section. I think all of that will be dating back to your statutory interpretation. I think that exercise can be done even before the fact sheet is released, because if you have some preliminary knowledge about the subject, comprehending the facts will be absolutely easier. And I think how exactly one should comprehend the facts will now be explained by Tushar. Yeah.
Thank you, Saunak, for actually comprehending and analyzing the fact that why preliminary research is very much important. And I guess it is very much necessary for you guys to understand that before approaching the actual moot proposition, you should be aware about the area of law that you are actually getting into, delved into, which leads me to the very fact that how do you approach the moot problem? Now your team is set, you have the moot proposition. The first aspect and the first tip from my end is to read as much as you can, because it goes without saying that as long as you keep reading the moot proposition every hour, every day, something new, something or the other pops up. Because of the very fact that if you stop reading a moot proposition, you will be actually, devoid of certain aspects which could, lead up to your case, because there are certain loopholes in every moot proposition that come up as soon as you read the case again and again. What I mean by this is that when you are understanding the facts of the case, you should be actually preparing a brief summary of the facts as the court finds them to be, because this is the aspect where I derive the material facts. Now, what are material facts? Material facts come out to be when you actually eliminate the facts that are not so relevant to the court's analysis. So while briefing a case and while making a list of, a summary of facts, your goal should be to actually reduce the information from the case into the format that will provide you with a helpful reference for review. By this, what I mean is that most importantly, while briefing the case and while forming a summary of facts, for a critical reference for review, you will grasp the actual issues, the relevant law, and how the court can, rule to the facts. This calls for an application and analysis of the facts, and you get to the issues ultimately. So my ultimate purpose of telling you is that you should take time to understand the problem in and out. So you could prepare a timeline of events based on the problem. That is what I call by, for example, if there is a case of criminal trial where there are certain dates which could be very much confusing. So what you can do is actually prepare a timeline of events based on the actual problem of the case. This comes in very much handy even if you are preparing for the oral rounds, because they help you in actually understanding the critical dates where a judge poses a question to you. The first few times you have to read the problem, read it only for the sake of understanding the flow of events and the chain of events, and create a timeline of events. When you are done with the brief line of creating the timeline of events, the ultimate fact is to actually prepare a brief summary later on, which will help you in the furtherance of facts. Now, when I come to reading the facts, it calls for an application or analysis of issues. So what is an issue? Issues are basically what are the questions presented to the court. Now, in easy words, I could say that what are the parties actually fighting about, and what are they actually asking the court to decide. For example, in a case of, let's take an example of a case of an assaulted customer, wherein the issue for a trial is for the court to decide whether the business had the duty to the customer to provide security patrols. Now, the answer to this question will help to ultimately determine whether the business is liable for negligence here and failing to provide security patrols and a duty to care. So this is your issue here, because whether the defendant owed the plaintiff a duty of care and what the duty of care is are the key issues in negligence claims here. So what I need, this leads me to the very fact that what is IRAC and CRAC. IRAC simply stands for issue, rule, analysis, and conclusion. CRAC stands for conclusion, rule, analysis, and conclusion. Let me just repeat it for the sake of brevity. IRAC is issue, rule, analysis, and conclusion. So we basically follow this pattern while analyzing a moot proposition, that how to go about it. Basically, it is a method for organizing a legal analysis so that the judge can follow your arguments while you are arguing and also while you are submitting a written submissions. How to go about it? Basically, let's take another example, whether we can look at an example, whether someone can sue for battery as a result for inhaling secondhand smoke. Now, the issue comes up here that the issue will look at it this whether there is a contract which is required for a battery claim. Now, the issue could be that what issue could be tackled is that the first state the question or the problem that you are trying to answer. This can be in the form of a question or a statement as well. Issues are not exactly questions as well, but this can be in a form of a statement as well. So in this proposition, the issues can be derived as such that whether a contract occurred when the plaintiff inhaled the secondhand smoke. This is an issue. This is actually followed by the rules. Now, when do you use the rules? Rules are actually determined what the relevant rules of law that the court uses to make the decision. We are talking here about the statutory provisions that apply to the present issues and how you back it up by the actual cases there. And subsequently, when we talk about the rule or legal principle, this may also take a form of stating the elements required for a prima facie case. This is actually followed by analysis of the issues where you adduce the evidence, cite the case laws, and actually arrive at a conclusion. So this is the IRAC method which we follow, and that would be dealt with me in detail when I talk about drafting the memorial and structuring your arguments advance and summary of arguments. Over to you, Saunak.
Yeah, I think that was brilliantly explained. But if I may just crave liberty to add two things to it. One is when he definitely mentioned about material facts, there is something also called as undisputed versus disputed facts. What you can also do as an exercise is you can prepare a table. On the left, you can all have the undisputed facts of the case. And on the right, you may have the disputed facts of the case. Ideally, what Tushar referred to material facts will qualify under disputed facts of the case, because that is what will take you towards your issues as really well explained by Tushar. But let me just also give you the instance where undisputed facts will also become really, really important and how that actually can turn the whole case in your favor. I'll give you one example first, and then I'll explain you how things work so far as the undisputed facts of the case are concerned. Now, there was a situation where I was in the final round of a moot, and it was a criminal law moot. And the issue was whether 50 milliliter, that was the undisputed fact so far as the figure of a chemical was concerned. So whether 50 milliliter of epinephrine, which was a chemical, can be the cause of death of an individual. Now, I had done a good amount of research with respect to medical jurisprudence. Going beyond the law, I will be explaining how one should also do some research beyond the law, but let me just give this example first. Now, my argument was 50 milliliter is not enough because I was supporting my argument with certain scientific evidence and data that minimum 250 milliliter is required for causing death of an individual. In that situation, I used this 50 milliliter, as an undisputed fact of the case to turn the case in my favor, that when I was arguing on behalf of the defense, my argument was the prosecutor has miserably failed to prove the case because of the fact that, 50 milliliter is not even, is enough to cause the death and hence can't be the main source of, death or cause of death. Therefore, that was the kind of analysis, and the judge immediately appreciated the argument, even before the rounds were completed. Therefore, you never know where the undisputed facts can actually help you in a case. I think undisputed facts play that role of being the X factor for your moot. So how you interplay that undisputed facts within your material or disputed facts will be very, very important. I will always suggest that, undisputed facts help you connect the dots between two arguments. So if there is a disputed fact, that will obviously take you to your questions of law and questions of fact. But if there is an undisputed fact, that will be like the second step between your first and the third step. So if you want to go to your third step, you need to cross the second step, and that's your undisputed fact. So that is what you should absolutely keep in mind. So having said that, let's proceed towards the next segment of this session, that is research methodology. Now, what we are trying to do, as I'm sure you must have understood by now, is we are following the same sequence as if a mooter goes from day 1 to day 30 of the moot preparations, right? That's what we are trying to do. Therefore, after you interpret your facts, after you analyze your issues at hand, what you need to do next, obviously research for the issues, right? Therefore, I'll suggest you a 3-step research methodology. The first step is, I was always, as a mooter, I was an old school guy, and I used to rely back on commentaries. And I feel that that's very, very efficient and effective, as well as it gives you the holistic and complete picture of what you are actually interpreting and what you are actually looking at, right? The reason for going for commentaries as a basic source of research is, for example, there is a statute of 1960, for example. Now, first of all, the commentary will help you understanding the background law that I mentioned before. Second, the commentary will also give you a clearer picture as to how the law has evolved between 1960 maybe till 2010. That is the date of publication of that commentary. It may be silent on 2010 to 2020. I'll come to that later as to what happens there. At least for these 50, 60 years, what you will have is the complete information as to how the law has evolved, how the Supreme Court and different high courts have interpreted the provisions of the law, how it has been applied with changing times, changing societal values, etc. Whether there is a change in interpretation. The best and foremost example is Article 21. The way Article 21 has evolved throughout since inception in 1950, and how the constitutional interpretation has changed time and again to make it more and more expansive. If I may say it, and that's a fact, it's the smallest article with the widest interpretation, right? And that interpretation for you to understand, I think nothing better than the commentary, because if you go for online research, you will be, struggling between making out a proper chronology of events as to how the law has been interpreted. But what you will easily get from a commentary is how exactly the law step by step evolved, whether the law has been overruled, whether a judgment was particularly not taken into consideration, and hence is there an element of per incurium, which is nothing but, when the judgment is invalidated merely because it has not taken into consideration the prevailing law at hand. Therefore, to analyze these aspects, maybe if you just go for online research, what will happen is you will be in a fix. You will be in a situation where you are relying on a 1968 judgment without even realizing that has been overruled in 1999. Therefore, to have that clarity of picture, to have that clarity of thought, commentary is really, really important. The second advantage of a commentary is you get a wide variety of case laws under your basket. Therefore, what you have is, if a judge is not getting satisfied with Kesavananda Bharati, you show EP Roypa. If EP Roypa is not getting, not coming to your help, you show another judgment. What happens with that is you have 6-7 judgments for each proposition under your belt, and you have 2-3 to cite in your speech. You can have 2-3 in your back of the compendium. And what you can actually do is, if the judge is not getting convinced or is deliberately, like judges, like I personally enjoy, not accepting, even though I know it's what he's saying is correct. I just test the patience of a counsel who is arguing. In that situation, what ideally happens is we would appreciate as judges, and every judge would appreciate that, if you can give us more and more judgments to prove the very same point. You can always say that, Your Lordships, please look at this judgment, which also reiterates the very same aspect, and therefore concurs with the opinion of 1990. Therefore, what you should, just to crystallize this and summarize this for you, what you should ideally do is rely first on landmark judgment, have 2 additional judgments with your research, and thirdly, have a very, very latest judgment, so that no one can question your research, and it will show that you have researched from all possible ambits, and that will be good so far as your case laws are concerned. Now, second step in the research process after commentaries can be your online research. Now, online research, some databases, if I may just name it, if you, because obviously the Supreme Court also names them, the fact that SCC Online and Manupatra are really, really good so far as your online research in domestic laws are concerned. For international laws, I think you can rely on JSTOR, you can rely on Cluo if it's arbitration, you can rely on, various other things like Hen Online, you have Westlaw and LexisNexis, all of that will flow in. But yeah, please never rely on India Qanun, please never rely on general Google search. Okay, I will name them, I am naming them out for the simple reason that, those are not trustworthy, and your judgments will be thrown at your face if you're relying on them. Therefore, please make sure you follow these small things. And ultimately, why online research is important is because they will give you the latest information. They will tell you what happened between the 2008 to 2020 period. Plus, they will also clearly map it for you as to whether a judgment has been overruled, and all of those kind of technologies can definitely be used, and that will come your way to make things easier for you, right? The next step of research, which I think many of you don't follow, or if you follow, that's really great, is doing some ancillary research. Now, ancillary research for me as a lawyer, I always feel that if I don't correlate law to other fields that I'm arguing in, then I'm not doing justice to the proposition. For example, I just explained, right, the 50 milliliter reference could not have been possible without reading medical jurisprudence. Similarly, when I was arguing in Stetson Moot Court, which is on international environmental law, the whole research was based on scientific task forces reports, validation committee reports, multiple policy decisions of different international institutions, non-governmental body reports, and whether they are even helpful and what binding nature do they have. These are the primary questions that govern in those kind of moots. Therefore, the best idea to go about them is go for Law Commission of India report-based research, go for policy incentive-based research, as in whatever the policy documents are, really good policy institution-based reports can be relied on. Ultimately, it's undoubtedly a fact that they are not binding on courts. But what you can actually do is you can rely back on a Supreme Court judgment, which may have cited a Law Commission of India report, and then say that, you can always argue, referring to that judgment, that the credibility of the document and the institution cannot be questioned. What should be therefore looked at is whether the document that I'm referring to will apply given the facts and situations of my case. Therefore, if I can at least prejudice the bench with respect to my side or my favor, I will succeed there, unless so contradicted by the other side as to why the document should not have been relied on. Right? Therefore, you can definitely do these ancillary research. Foreign judgments will always help in your interpretation. It will always have persuasive value. You will have multiple judgments of the Supreme Court stating that unless the foreign law is contradicting with the domestic law, the foreign law can be used as a guiding factor or a guiding light. Therefore, you can definitely do those research. Apart from the Supreme Court judgments, go for some common law based decisions, go for House of Lords, go for US Supreme Court's decisions and judgments. Especially, I'll give you an example in intellectual property law, for example, there is hardly any precedent in India so far as the international trademark and patents are concerned. And Delhi High Court judges have time and again relied on the US Federal Circuit Court decisions for that matter. Therefore, all I'm trying to say is, unless there is any clear inconsistency between foreign law and domestic law, foreign law and jurisprudence can be used as persuasive value before Indian courts. So your research will always add as that extra factor that will, show to the bench that, okay, this team has at least done something extra, and that will be very, very important and relevant. So that's a 3-step process of research, just to summarize and crystallize: commentary, followed by online research, followed by ancillary research. Yeah. Tushar, up to you.
Great. Thank you, Saunak, for explaining the mechanics of legal research. So I just have a couple of points to add on to what Saunak said. There is this art of judgment reading, which is very much important. So when we are, like Saunak mentioned, to understand the US cases, the Federal Circuit decisions, those are based on a high level, analysis and, interpretation. And to understand, you need to understand the art of judgment writing. Now, judgment reading. Now, what I mean by judgment reading is you need to get into a habit of reading one judgment of either a High Court or a Supreme Court judgment every day, because it is very much acceptable that if you are actually reading a judgment every day, you get a hold of getting a hold of the fact that how a judge thinks and how the legal language is used, and understanding where a part of the judgment is called ratio decidendi and obiter dicta. So what I mean by both of them is you need to actually divide and you need to adduce the ratio decidendi out of the judgment while understanding a case law, because the ratio decidendi is the very fact and are the very principles of law formulated by the judge while making the decision. And the ratio decidendi, for the very sake of importance, is a very necessary step to actually reach to a conclusion where a judge formulates a judgment. And secondly, it is very much directly related to the issue. Now, ratio decidendi can be in the form of a common law rule, or it could be an interpretation of a statute, or it could also be an interpretation of a common law rule. Secondly, obiter dicti are the observations made by the judge, which are basically not essential for the decision reached. But these are not even binding, but these are actual observations as such. So you need to distinguish the ratio decidendi and the obiter dicta. And my ultimate tip while judgment reading would be like, while you are arguing in the court of law, in the moot court, or maybe you are also citing the cases in your written submissions, never cite case laws that you haven't read completely, because there might be chain of events where you could actually feel that yes, this case might be applying to the present facts of the case, but the decision might turn out to be very different. And for example, the cases the facts are sometimes similar, but they ultimately lead on to another conclusion. And it is very much essential, as Saunak mentioned, that the case should be actually checked upon if it has been overruled, or and if it is actually has to be seen whether it is per inquirium, for the very fact that per inquirium very much means, and it could be translated to a very easy aspect, that through lack of care. And it also refers to, it happens so when a judgment of a court is very much linked to the very fact and has with no reference as such to a statutory provision or a precedent as such. So this is a per inquirium decision, which is very much not suggestible to applying in moot courts. And this is where I lead to the last point, where use of legal dictionaries and use of legal legal terminologies, legal maxims. You need to understand all of them, and for that you need to actually you can refer to the Merriam-Webster's dictionary, the Black's Law dictionary. I mean, dictionaries are used for the very fact that you need to cater to some legal terms which are very much understandable. Over to you, Saunak.
The next thing I think we should cover today is the memorial aspect. Memorial is nothing but a consolidated written submissions or a written statement where you collate all the information and your research and put it across as a legal submission that should go to the court, right? And therefore, in the memorial, so why don't I just share the screen for that matter and show you all a memorial which had fetched me an award for that matter. And what I'll do is I'll go page by page quickly. I won't take much time over there, but what I'll try to show is a general structure of a memorial. Because memorial ideally has a 10-part structure. Out of 10, I'll be covering it until statement of facts, and post statement of facts, Tushar will be taking up all of you through your other aspects. So I'm trying and sharing my screen if that's possible. Tushar, if you can just let me know that if you can see my screen. I'm trying to show it now.
It is very much visible. Yes.
Okay, perfect. So if all of you can see the screen, you know, what we have right on the top right corner is the team code. What is a very important aspect is the first thing that should be mentioned in any memorial is what is the forum before which you are approaching, or the forum where you are actually going, right? So here, this was a memorial before the International Court of Justice. Therefore, I have mentioned the forum right on top. Then the second element of any memorial, may it be domestic or national, is the provision under which you are invoking the jurisdiction of the court. And that should be mentioned right on the top again, right? So therefore, I've mentioned the provision that's Article 40, Para 1 of the ICJ Statute, and I have invoked the jurisdiction under this provision. This emblem ideally goes into international law moot memorials, need not be there and should not be there, in fact, in domestic law moots. That's the only difference in the cover page between an international law moot and a national law moot. The next thing is the cause title that we ideally call it. We have, if at all, we have a summary of our case name. We mentioned that, like over here we had in the case of Turentia, in the case concerning Turentia News Network. And over here we mention the party name and we mention the designation versus the respondent of the counterparty. Right below we mention that for whom we are filing the current written submissions. That has to come out very clearly, or else it will lead to confusion. The blue color that you're seeing as a page color is ideally because of the fact that the moot court rules will clearly specify what color should be the respondent's memorial first page as well as the applicant's first page, and you need to follow that. There will be situations where matters are clubbed, where matters are tagged. They'll be not very simple to come to the cause title. In that situation, if the jurisdiction remains common, if everyone has approached, for example, in terms of Article 32 of the Constitution, what you can do is it should be simply A and others versus B and others, where A is the first party which has approached to the court and B is the first respondent in that first matter. And others will include whatever number of other matters have been filed, so they have been tagged. That's how things work. If there are different jurisdictions, for example, someone has challenged the constitutionality of sedition, and on the other hand, someone has challenged a conviction under sedition, and both of them are now clubbed together because the issues ultimately maybe have, or it's a possibility that there will be similar issues, therefore they are clubbed. In that situation, you need to distinguish the cause title, you need to show different jurisdictions and mention the name of different parties separately, but all in the single page cover. It cannot be more than one page. The next page in any memorial, I'll just shorten it a bit. This is the index, where you can see that everything containing in the memorial is clearly reflected here, along with the corresponding page numbers. We have the written submissions also. And we have, this is nothing but the arguments advanced. And if you can see, I have also extracted all the major submissions, sub-submissions, and further sub issues in the content itself. It's very, very important to give the holistic picture and the impression to the evaluator right in your index itself, so that someone who sees your index will be like, oh, you have covered all these points and this seems great. And that should be the ideal approach that you can follow, right? So if you can see here, this was my first issue, which was relating to jurisdiction. If you can see, I had distinguished my sub-issue as 1.1, 1.2, and 1.3. If you can further see, I had further distinguished my sub-issues as 1.3.a and 1.3.b. So these are nothing but a broader head, and what exactly I'm arguing under that broader head gets converted into a small single sentence that becomes my heading and subheading, right? That's exactly what we do in the arguments advance. I'm sure Tushar will be explaining that in detail. Before that, if you may see, then we have a list of abbreviations at the third segment of any memorial. This should consist of all the abbreviations and the expansions. Make sure once abbreviated, you do not use the expansion again and again in the rounds. And again, I mean in the remaining portion of your memorial. So this table can go the way it is, right? And then is the index of authorities. Now, because it was an international law moot court competition, we had an index of authorities where, the international legal instruments come first, because that's how things work in international law. Just to summarize the hierarchy in international law, ideally, it's treaties and conventions, followed by customary international law, followed by general principles of law, and finally the judicial precedents and decisions. Therefore, the first column I had in my index of authorities was international and regional legal instruments, which was binding on me. Then we had the list of cases. I had distinguished all judgments into different tables. If you can see, we first had the ICJ and the PCIJ judgments. Then we had the UNHRC judgments, which is the United Nations Human Rights Courts. Then we had the European Court of Human Rights and the decisions over there. Similarly, Inter-American Court of Human Rights, African Court of Human Rights, Supreme Court of United States, judicial pronouncements from United Kingdom. Now, this was an international law moot memorial. Therefore, you are seeing such variety of decisions. Had it been a national moot court competition, it would have been Supreme Court, followed by High Court, followed by international judgments, if any, right? But what remains common is the book cited. You will have to write the full name of the book in the terms of the rule book, etc., and give the page numbers where these are referred inside your memorial. This just instills the confidence in the mind of the evaluator that, okay, whatever you're citing has actually been referred throughout, right? So that's how things work. Then if you can see, we have academic articles. This is what I had quoted. And finally, the statutes applicable. If there is constitution which applies, please make a separate column and write the constitution, because constitution is not a statute, right? Therefore, I see that, fault being there in many memorials. Therefore, I just thought of pointing that out. So what I did over here, you can see there are plenty of authorities, but honestly saying, I had read them each and every authority before my moot. Or else, if you are not reading anything, but you are simply citing, and if a judge is asking you a question from this table of authorities, then there can be nothing as bad, and as in you can't in a way, that's the last thing that you can do in any moot, right? Therefore, read the authorities that you're citing in and out. Without reading, please don't quote them. Next thing we have is a statement of jurisdiction. Now, please understand, statement of jurisdiction is nothing but where you clearly explain to the bench as to why they have jurisdiction and why they are competent to hear your matter. Secondly, why you are competent to stand before them. And thirdly, why the issues that can be dealt ultimately by the same court. So these are the three purposes of any jurisdictional purpose. And therefore, what you should keep in mind is whenever you are approaching towards the jurisdictional issues, make sure you satisfy the preconditions for every jurisdiction. For example, it's an Article 32 petition, for example, a PIL. What you need to first satisfy is, number one, you have the locus standi. Number two, that there is an infringement of fundamental rights. And number three, that the infringement of fundamental rights was on the instance of a state in terms of Article 12. If you are not proving that, obviously you will fail in your jurisdiction. Similarly, what you should also keep in mind is whether the relief that you're asking for, whether the court can give that relief to you. Now, for example, if you're going for a consumer forum litigation and you're asking 1 crore as damages or compensation, but you're going to a state forum which cannot give you that amount, then your case will fall apart. You're not serving your client, and that's not taken as an appropriate course of action. Therefore, please choose your jurisdiction well, understand where can there be a alternative remedy and whether you should avail that alternative remedy, and or whether you should actually go ahead with the general remedy. Understand the difference between general versus special law. When a general law will apply, when a special law will apply, you will see that a lot of things are overlapping. In that situation, the special law being specific will prevail over the general law. There are certain exceptions where the general law will also prevail over the special law, but you need to be very, very clear, and let's not go into all those legalities. But all I'm trying to say is there are a lot of considerations before you should finalize your jurisdiction, because the first thing I as a respondent counsel used to object was obviously jurisdiction, and therefore my primary instance was your lordships do not have jurisdiction, therefore the merits of the matter need not be gone at and need not be looked at the first place, and without prejudice I'm making my submissions. That used to be my approach, and therefore you do not want to be in that situation where your respondent counsel is coming up and saying that and you're unable to report that. Therefore have your jurisdiction intact. The next thing is statement of facts. You need to summarize your statement of facts in such a way that it gives a clear picture of how things work and how everything goes into the limelight, and therefore only those undisputed, unbiased facts should be reflected in the statement of facts. If at all you are looking for disputed facts to be mentioned in statement of facts, make sure that you are actually, elaborating them well and clarifying that this is disputed and hence we are approaching this court. Right? Therefore, that clarification should be there, because at the end of the day, you assist in the bench. You should not have biased statement of facts in your memorial. So with that, I'll now leave it to Tushar to continue with the other aspects. Tushar, do you still want me to continue with the presentation?
Yeah, please go ahead with that
Yeah.
as soon as I continue them. Thanks, Saunak. So as Saunak mentioned, the first half of the memorial that we have, we move on to the statement of issues that we have later on. As we discussed earlier, how we deduce the issues of the case, you need to simply mention them in crisp words, where, as it is, as you have framed those issues. When you are dealt with the issues, you just need to, there are, in certain moot propositions, there are issues given in advance. In certain moot propositions, there are issues not even given there. So you need to actually formulate your issues well in advance, despite the fact whether they are actually given in a moot proposition or not, and actually present them well in the memorial as cited above. It is very much important to consider the fact that when you are making a memorial, it is that the memorial should be uniform. Like you can view in this memorial, there is equal line spacing in between every arguments and every points that has been made. There is equal referencing. The paragraphs are actually numbered well. There are page breaks here. There are header and footers there. So my ultimate purpose of telling you is that before structuring your arguments, you should be also mindful of the fact that you are actually structuring the memorial as a whole. And once you start formatting from the very beginning, it would help you and save you much time when you are actually writing your arguments advance. Saunak, could you just lead it to the summary of arguments?
Yes.
So after we are done with the issues and when we are presented the issues, next is the summary of arguments. My suggestion and what I do follow in my moot courts is that I first make the arguments advance, for the very fact that summary of arguments, as the name suggests, are the ultimate summaries, the ultimate gist of what you are actually going to argue and what is it going to lead to. So the summary of arguments are actually just a minor portion and a basic gist in just 3 to 4 lines about what you are actually going to argue. The summary of arguments do not contain references and do not contain provisions which are quoted. This is an actual logical representation of your entire argument. So the essential idea is to, and the aim is to present a logical line of reasoning in support of a case. So the logical reasoning behind the arguments advance is what is put in the summary of arguments. You should actually show the bench in the summary of arguments what you are going to address the issues, how you are going to address the issues, and later on we come to the arguments advance stage. So when we move to the arguments advance, Saunak, can you just move it further to arguments advance?
Yeah.
So this is a clear-cut example of how we draft the arguments. it is very much essential to understand how do we use the mechanics of legal research and incorporate them into words, because there is a clear-cut difference between writing and legal writing. What I mean by this is that you need to be aware of the legal maxioms, you should be aware of the legal terminology which should be applied while drafting an argument, because the ultimate idea is to present the judge with your arguments in and address the issues in such a way that the law is applied to the facts of the case. As you can see, the present issues here, the laws have been applied to the facts of the case, because you need to actually connect the law with the facts of the case while you are arguing, because until and unless you connect them well, you are actually arguing the law alone, or you are actually arguing on the facts alone. It is a very different story, because if you can't relate the law to the facts, there is a clear-cut example of the fact that how you cannot apply law to the facts, and to the very fact, in addition to the legal language presented, you can formulate your draft properly. The essential idea of arguments advance is to showcase a picture and represent a logical line of reasoning. So you start with the very fact, and let me just bring up the IRAC rule again, where we lead on to the issues raised and the rules. Now, what I mean by following IRAC in arguments advance is that after you are posing an issue there, you need to actually start with the provision you apply, or the legal rule you apply, or the statutory provision you apply to the present case. And the prima facie case for it, for example, let's take the example of our previous battery example. So in the present case, when we apply the legal principle here, the legal principle would be that the prima facie case for battery requires the following elements. So the elements of battery could be an act, it could be intention, it could be contact, it could be causation, and it could be harm. So when you are dealing with all these essentials, you need to actually present them in a logical way as to, yes, these are the essentials of the of battery, and then you need to make an analysis of it. This leads me to the IRAC rule, the third part, which is the analysis part. Now, after you have actually determined the rule which has to be applied on your argument, you need to actually state the evidence and explain how will you arrive at your conclusion. By this, you need to actually cite other case laws in support of your argument. And you can also discuss policy implications of the law. You can also discuss cases that run counter to your conclusion, but that is not advisable, because you need to actually support the argument with the cases which align to the present facts of the case. It is very much advisable that you research case laws which apply to the facts of the case, because of the very fact that if you find a precedent to your very much case, your case is actually settled, because you have a settled aspect of law there, and the court has actually is bound by it. If it is a Supreme Court decision, even if it is a High Court decision, and it acts similar to the present facts of the case, it could aid you in a very absolute way. And as you can see how we draft those legal arguments, the very essential fact is to, after the analysis, to conclude them. So as you can see, there is always a last paragraph in the present memorial, which actually concludes the memorials. Like if you can see that this is the present sub-issue there, which is actually summarized there. After the summary and after the end of the issue, Sonu, could you just move on to a conclusion of this present issue?
Yes.
So as you can see, there are sub-issues involved in the present case, and what the arguments advance showcase is that the present paragraph is actually depicting a logical sequence of arguments which are going to be dealt with using the rule analysis. In the second 46th paragraph, as you can see, it is concluded after citing the authorities here. So it is ruled by saying that the court is likely to find that in the present case that the harmful contact occurs when a smoker releases secondhand smoke into the air, and that the air is inhaled by a bystander. So this is how we actually make the summary of arguments and the arguments advance, and which leads me to the summary of arguments, for the very fact that when you've made your arguments advance, you just need to summarize them in a very crisp manner. Like, you don't have to follow the IRAC rule here. You just need to actually conclude it into your gist as to what you actually tend to argue. There is no need for a conclusion. There is only a need of a logical analysis in the summary of arguments. With that, let me just lead on to the prayer of the memorial. So in the prayer, what prayer is that in the prayer, what relief are you requesting? That is the ultimate aim of the parties, that what relief are you there in front of the court? What can the court grant you? What is the wish of the parties? So this is a standard line which, Sonu, can you just zoom it a little bit? this is a very standard line for prayer, wherefore in the light of questions presented, arguments advanced, and authorities cited, the Democratic Republic of Turania requests this honorable court to adjudge and declare the following. This is a standard line which we use in moot court memorials, and it is very much standard in every memorial, apart from the international moots, as it is depicted here. And you need to be very crisp with the very fact that sometimes what mooters do is that in their written submissions, they use the issues presented as the prayer used, which is not exactly wrong, but it is very unclear to the judge, because you are actually arguing onto your issues, but your prayer can be a very much different, because sometimes you can ask for a restitution, sometimes you can ask for compensation, sometimes you can ask for damages, sometimes you can ask the court for staying of proceedings. So your prayer should be very much different and to the point. And that leads me to the very fact that after your conclusion of the argument, where you have actually mentioned in your arguments advance that how you're going to conclude, the ultimate prayer for the very purpose is this, that after you are done arguing in the court and after you are done submitting your written submissions, that is the ultimate request for the prayer. So that is how a prayer has to be recorded. And secondly, at the end of the prayer, that there has to be a sign of the advocate. Can you just lower it down? Yes. So you need to actually mention that in respect of the above made submissions, all of which is respectfully affirmed and submitted, and you need to mention your role here. If you are the applicant, you are the respondent, you need to mention your clear-cut role here. Over to you, Saunak.
Yeah, okay. So I think that covers your memorial aspect really well, and I hope all of you have understood how it and what it takes to prepare a good memorial. So far as what are the key ingredients of the same, I'm sure there's no straitjacket formula for making a memorial, but I'm sure we could at least give you a guiding path so far as to how exactly you should approach towards your next moot court memorial. Coming towards the next thing, I can also realize that we are running short of time, but I think we'll cover the oral advocacy aspect. And basically what I want to share is my personal experience of how I used to proceed towards oral advocacy. And Tushar will be sharing his personal experience, so that what you will get is two distinct and different approaches of two different speakers. And I'm sure that will cover at least the broader category of speakers. So what happens ideally is, for me, my speech never used to start only when I used to submit my memorial, for example. It used to start long back. My speech used to start the moment I was ready with my first sub-issue. Therefore, because honestly saying, I'm not a great speaker, I'm not a very good speaker. I lack in my English pronunciation and a lot of other aspects. But what I used to deal with and what was my benefit or my strong point was my research. Therefore, I used to be confident, and I made sure that I used to prepare so well that, okay, at least I was able to answer all the questions, and that's the main element of any speaker. Therefore, what you need to make sure is prepare your speech right from scratch. And my first speech was always a final speech. Whenever I prepared my first speech, it was a comprehensive speech of about like 20-25 pages. I won't call it a speech, I call it a record. And what I ideally do in that is, or I used to do, in fact, was, we had a lot of cases being referred, for example. I used to make sure that I name the case and the citation and the judge's name in different colored pens. And I used to extract the whole para in another colored pen so that it comes out quite clear. And the rest of the speech was in front of me on the right side of my A4 sheet papers. And on the left side, I used to have certain anticipated questions regarding the issue and the tentative answers or the potential answers that I wanted to give, along with case laws to back them. The benefit of this was, first, we had a series of judgments already with us. Second, we also had anticipated questions, plus answers, plus judgments. So whenever a question used to come, or whenever a judge used to ask us a question, my first response was easily, I used to relate to a case law and answer him back. And they were always surprised as to how could I anticipate a question and answer them back with a case law. Because you answer the question, someone can understand. You answer a question with a case law, someone will think that, oh, you did that research also, and therefore you could answer. So the objective was to leave this kind of an impression with the mind of the judge, so that they will think that, okay, this team has done a great amount of research considering all aspects governing the law. That was always my approach. The second thing I used to do was, for example, if there were 50 resources, as in the legal resources, which I used to cite in my speech, in my final speech, for example. Then I used to prepare a compendium. I'm trying to relate a speech in a compendium. I'll explain why I'm doing that. The speech used to have in the chronology of say 1 to 30 or 1 to 50. And I used to just number them as 1, 2, 3, 4, 5, 6 up to 30. So for example, if my first case was PUCL versus Union of India, the second case was Kesavananda Bharati, the third case was, for example, Aadhaar privacy judgment, then I used to number them as 1, 2, 3, 4. The same chronology of the sequence was also followed in the compendium, where I used to print the very same documents, and I used to prepare a proper compendium, which was nothing but a spiral bound document of all the legal resources. And I used to prepare the copies of the same. I made sure whatever the bench strength was, for example, if I was arguing before a 2-judges bench, which is a division bench, I used to give them 2 compendiums. I used to carry at least 5 with me, because in final rounds, mostly you face 5 judges. So whenever I used to go to final rounds, I used to give them 5 sets of compendiums. My team never used to have a copy of the compendium. The benefit for that and the reason for that is my speech had all the cross references. Therefore, the judges used to think that we are relying on a compendium, but we are actually not having a compendium with us. But they don't know that everything is in our speech, right? So that's the mind game number 1. The second approach is, please understand that what I used to do when I used to cite a judgment, I simply used to argue that your lordships may kindly refer to flag number 3 of the compendium, wherein the judgment of Kesavananda Bharati is mentioned. I'm quoting para 45 of the judgment. I used to explain them the judgment by looking straight at their eyes. I never used to rely on my speech. The benefit of that, number 1, is you are saving a lot of time with your researcher standing up time and again and passing judgments to the bench. Every time your researcher passes a judgment, you lose 10 seconds. 10 times that happens, you lose 1.5 minutes for sure, right? And that's a demerit in any given moot court competition, because you lose a lot of amount of time. The second and the more beneficial approach out of that is, what happens by that exactly is, the judge validates your submissions. The judge simultaneously goes through what you're arguing. So your arguments get validated. There's no, rumor or doubt in the mind of the judge so far as the correctness of your arguments. So whatever you're arguing is getting validated through the documents, and that's happening parallelly, that's happening side by side. Therefore, it saves a lot of time. It gives credit for your arguments. It validates your arguments. And that's a very, very good way as to how you can actually navigate the ocean along with the judge. Therefore, please understand that if you can, then please rely on a compendium and use the compendium as a navigating tool to argue your whole case. Therefore, just to conclude on this aspect, the last thing that you should do in your compendium is flag them and just number them as 1 to 30. Instead of numbering them as Kesavananda Bharati and writing the full name of judgments, just write the numbers, because you already have the cross-reference numbers in the speech. What happens by that ideally is, you will have all the key ingredients with you. You have the cross-references with you. Plus, it's very, very convenient for the judge to just look at the flag number 1 and open it. There's no wastage of time. There's no effort required by the judge. It's smooth, it's transparent, it's efficient. That's how things work. The last thing I want to tell about, the oral advocacy aspects is, make sure you deal with a hot bench really well. By hot bench, I mean someone who grills a lot. What happens there is, you need to identify the fact that a judge understands that if he or she is asking you a lot of questions, you obviously do not have the time to cover all your arguments. 2 ways to deal with it. Number 1, give answers to each and every question right at the moment it is asked. Never say that I'll come back to it during my second issue or my third issue, or the fact that my co-counsel is dealing with it. All these approaches won't help. The main thing, if a judge is asking you a question, answer it then and there, let it go. You can answer it briefly, say that I'll be covering it in detail subsequently, or say that I'm answering for your lordship's convenience, but my co-counsel will be explaining the aspect in detail for greater understanding of the bench. That is how you need to deal with it, instead of straight away saying, no, I don't want to tell you now, right? The next thing that you should keep in mind regarding this very aspect is, you know what you are going to cover. A judge doesn't know how many issues you are going to cover. Therefore, don't make it look evident that, oh, you are left with 5-6 issues and you're already running short of time, because you're marked for your time management. Therefore, if you have not covered 2-3 issues, take 30 seconds, 1 minute to summarize the key major submissions from that, and say that I've placed my written submissions and that may be taken into consideration, and the judge will definitely appreciate that. So that's all I wanted to share. Some key insights regarding oral advocacy aspects. Use your compendium well, because honestly saying, I've won most of my moots only because of those compendiums being utilized well. And that has always been appreciated by the bench, because the judges always want a sense of, kind of validation from their end, and that the documents give them. Because honestly saying, you have prepared for 3-4 months for any given moot. A judge, maybe tomorrow, if I'm asked to judge international human rights law moot, I may be knowing the basics of the subject, but I may not have researched the way the people have researched who are participating there. Therefore, I will always want documents so that whatever is being argued is proven in front of me, so that I also make a rational mind and give my conclusion and my feedback or my marks to the participants. Therefore, for that purpose also, it's important to have documents and validate everything. Especially, I saw a question from someone which popped up. I think that was regarding online moots and how to deal with the compendium or a PPT as such. What you can simply do is convert your compendium in PDF, bookmark it well, and present it on screen just like I did my memorial. I think that's how one should proceed. So I'm really thankful for everyone. I think I will have to leave the session now. I just have a conference. I'm really sorry for that. Tushar is here to continue. But in case there is any questions for me specifically, I can take it up in like 1 or 2 minutes, and then I'm really sorry, but I'll have to take all of your leave. Thank you so much, everyone. Thank you, Tanush, for having me. Thank you, Tushar, for being a co-panelist here. It was really amazing talking to everyone and interacting with the students. Thank you so much.
There are just 2 more points to cover. So basically, there are 2 mooting styles which I would like to talk about. Me and Saunak, we have a different mooting style. Like what Saunak does is that Saunak uses a speech. That's what I've actually mentioned, that what do you actually need in a moot court competition? Do you require a 25-30 page speech? Just 1-page document, you can make one argument for the very fact, and you can add 2 more cases as citations that very argument. In such a way, you just have a document to address the arguments, and for the very fact, if a judge differs you from argument 1 to argument 3, you can actually use your quality for that very much matter. And secondly, leads me to the very fact that why do you need skeletal arguments? So while researching, it is very much useful, always useful to maintain a document where you collect all the information that you think must go into your memorial. Most importantly, you should be building a skeletal argument for your issues simultaneously. You should be building a skeletal argument because you need to actually draft the arguments while researching. So if there is something you should do in your memorial submission which is very much close, so while you are collecting your thoughts, preparing a skeletal argument and getting your research in order before actually drafting the memorial can be very much useful. And to that very fact, the skeletal memorial as well as the mind map comes in useful because it's just 2-pager document which you need to carry. And I guess it comes with experience, and it comes with interest and how you are very much comfortable with. Both these approaches are very much flexible to adopt. It actually depends on the speaker as to what can you approach, because I'm not so comfortable with carrying a 30-page document and such heavy documents with me. I personally carry only 1-page document which actually consists of my mind map. So it actually helps me navigate everything, because the very fact of mooting is that you should not rote learn your speech, for the very purpose that instead of reading, you need to actually look in the eye of the judge, which actually shows you are confident about the arguments and you are actually able to answer the questions very much well. Which leads me to the basic tips of oral advocacy that I would like to address. Firstly, when it comes to oral advocacy, the language of a courtroom is very much different from that which is used in everyday speech. So you should, avoid colloquial phrases such as "okay," "all right." These phrases are not so acceptable. If a judge corrects your mistaken interpretation of a case, the correct response should be something like, "I'm grateful for your lordship's assistance," rather than "okay" and "all right." Speaking slowly is another key, because you shouldn't be speaking very much fast, because it is very essential for the judge to actually understand your arguments very well. And thanking people is always a good idea, because if you are thanking the judge rather than throttling them, it is a very professional aspect of a moot court, because it is very much also essential to ask the judge's permission at various stages of your speech. For example, with your lordship's permission, I would like to move on to the arguments advance, or I would take your lordship's permission, I would like to move on to the prayer. So as such, you should never tell the judge what you think, suppose, or suggest. The personal opinions are not there. Your role as an advocate is to assist and aid the judge, not
Guys, with that, you know, I can sense that, you know, there's a lot of audio problems, but don't worry. These tips about oral skills, you know, in a very weird sort of a manner, we'll have them sent in a written format. Tushar, thanks a lot for the presentation, for all your inputs as well. Participants, we've got a lot of questions. We've tried answering very fast, 110 questions. You know, there are 48 questions which still remain. We cannot, you know, address all of those questions, unfortunately, in this webinar. As I said, as far as the oral skills go, we'll send you a write-up. You know, we'll send you something. One of the questions which I saw from a career point of view was, is mooting useful for corporate law as a career? I would like to take that. See, any activity that you do in college which showcases that you have good research and writing skills, you're a hardworking, intelligent person, is going to be useful for your career. So whether it is about, let's say, acing your academics, you know, being in the top 10% of your class, whether it is, you know, doing really well in moot courts, whether it is maybe doing well in publications, or it could be even, you know, if let's say corporate law is not your area of interest, other things are, it could even be that you've done excellent work in, let's say, legal aid. So mooting is definitely useful, but it is not compulsory to be a mooter to have a great corporate law career. As a good mooter, when you know, gain experience, you gain skills, if you're winning, you know, these competitions, even, you know, like maybe a quarter finalist or something, that shows to any recruiter that you have excellent research skills, you have excellent writing skills, you can work in a team, right? You can speak cogently, which any recruiter would, you know, would want to have that. So I wanted to address that larger career sort of a question before we end the session. Thank you everyone for joining the session. And yes, thank you, Sumedha. You know, Sumedha has typed out a lot of answers on the Q&A box. Thank you, everyone. We'll see you next time. Tushar, any final words?
Nothing, just I would like to thank you, Tanuj, and thank you, Sumedha, for answering those questions. I was not even aware that the questions are popping up in simultaneously. And it was a pleasure for me to be here. And I hope we actually try to give you a background, because ultimately we cannot teach you mooting right here. And we are actually working towards it. Lawctopus is actually working towards a mooting course here, for the very fact that people need understanding about mooting. And if you have any other questions, I'm very much open to LinkedIn here, and I can assist you with all your answers and all your queries over LinkedIn. And of course, the tips on oral advocacy would be given to you in a matter of 1 or 2 working days. So thank you for your kind information. It was a pleasure for me to be here.
Right. Thank you, Tushar. Thank you, Sumedha. Thank you, everyone, for attending the session. Goodbye.